All right. Now, in our closing couple of minutes, I want to take just a couple seconds to look at the new rule for reinstatement of attorneys. It's Rule 1:20-21A. I've told you where they got that number from, so it'll be the next rule from Rule 1:20-21, which is the current reinstatement rule. Again, there are some things in here that we didn't discuss just now, but I want you to know about it. For those of you who are going to start the process on your own, read through the rule. It tells you what you have to do step by step. For those of you who are attorneys who are doing this stuff, go through here as well as the notes you have in your lesson plan here. All petitioners for rehabilitation will waive confidentiality, okay? Supreme Court Committee on Character Materials, and such other information and records as requested by this rule. So, anything that was embarrassing to you, especially stuff that was in the possession of the Committee on Character, like, plagiarism, like we talked about. Thank you, Johnny, for helping me with that. You're going to waive your right to confidentiality on that. So make sure your guy knows that ahead of time going in. Permanent disbarment and second offenses. We talked about someone who's been permanently disbarred following the effective date of the rule or who has been disbarred a second time may not file a petition. Again, this business about permanent disbarment is new, and no second chances, or actually no third chances, okay? Because you've already gotten a second chance, no third chances if you screw up again. Other disbarments. All the disbarment cases petitioner may file petition for readmission and publish a notice of their intent to apply for readmission 40 days prior to the expiration of the 5 years from the effective date of the disbarment. Okay? So for those of you where the 5 years has already passed, you can just do your notice right now. I put it in the law journal. I think you can never go wrong by putting your notice in the law journal. You may also want to do it in the local newspaper where you are, but law journal is always the way to go in these things as far as I'm concerned. As condition precedent to filing such petition, petitioner must, within 12 months prior to the filing of the petition, do the following. So you got 12 months before you're going to file your petition. Here's what you got to do. Pass the bar exam. The next one's in February. Sign up now. We just had a client who did that, signed up the other day. All right, number 2, pass the multi-state professional responsibility exam with a score of 75 or higher. And I mentioned to you before that was in the lesson plan, but that gives you the score of what you've got on that. 3, complete all continuing legal education courses Supreme Court designated as required. Again, they'll announce what those courses will be. Very top heavy on law office management and trust accounts, although people get disbarred for a lot of other reasons, okay, which they're not necessarily addressing. Additional criteria. Petitioner shall prove that he's fit to practice law in this state. Possession of requirement traits of honesty, integrity, fiscal responsibility, and trustworthiness, and professional commitment to the judicial process and administration of justice required for members of the bar. Petitioner may be readmitted to practice of law in New Jersey only if petitioner satisfies each of the following criteria. Now let's go back a step. Talk to your clients. What are you going to do in the next 5 years? Or what have you been doing in the next 5 years? Where I can write a brief to the board saying that these actions by you demonstrate the requisite traits of honesty, integrity, fiscal responsibility, trustworthiness, professional commitment to the administration of justice. Okay? Got to address all this stuff ahead of time. Think about it now. What have you been doing during that time period? It may be community service. It may be, something with the church. It could be a million things. It could be some kind of volunteer work. Nothing dealing with the practice of law, but by the same token, it could be, in the political sphere. It could be anything, okay? Just to show that your client is, and maybe your client has a job in a bank or handling money or something of that nature. Anything you can come up with that will satisfy these general criteria, all right? Put it in your brief when you're putting it together and have your guy be able to testify about it. Here are the other criteria. Full compliance with the terms and conditions of all disciplinary orders, temporary suspensions, fee arbitrations. You got to get the money back if you had a fee arbitration. And compliance with Rule 1:20-20, all right, which is, again, I told you, that's the rule. As an attorney, you should go through that step by step with your client. Make sure your client understands what the restrictions are on his practice. Petitioner has reimbursed or will reimburse the New Jersey Lawyers Fund for client protection and reimburse all items authorized to be paid because of misconduct unless there's extraordinary hardship. When we talked about that, paid all your registration fees and charges to the fund, has obeyed the applicable court rules in this jurisdiction and other jurisdictions where he was previously licensed, not engaged or attempt to engage in any jurisdiction in the unauthorized practice of law during the period of disbarment. I had this come up recently in a case where my guy got a job working for, what's the name of that big law firm in Florida? Morgan & Morgan, size matters, okay? For other people, they have a lot of advertising. He went to work in Florida, not as a lawyer, but as a salesman. And his job is he go around to law firms all over the state, personal injury firms, knock on their door and say, listen, I work for Morgan & Morgan. If you let me take over some of your personal injury cases, we'll give you X amount of, recovery of whatever we get. And when he was coming back to be readmitted in New Jersey, he had been suspended, he reported this to them, and they suspended him for an additional period of time and gave him a reprimand because he involved himself in the practice of law, and even this oblique, minimal involvement in the practice of law, really which he wasn't, but they regarded that, even though it was happening out of state and it didn't involve necessarily the direct practice of law, they disciplined him for that. So make sure your guy hasn't been doing any practice of law either in New Jersey or any place else, including other planets, okay? That's part of Rule 1:20-20. If you're suffering from physical or mental disability, infirmity at the time of disbarment or other prior discipline, including addiction, the condition, disability, or infirmity has been addressed, okay? Again, if you're representing somebody who's going to be disbarred tomorrow, address that. If your guy has already been disbarred and he wants to make an application, this is one of the things that he should be addressing, and you should be leading him through that process, okay? Petitioner shall not be readmitted unless he can establish three things. One, petitioner has successfully pursued and participated in appropriate rehabilitative treatment. This can be for gambling, drugs, alcohol, whatever it may be, depression. Petitioner has abstained from the cause of addiction for at least 1 year. No Atlantic City for you, Mr. Gambler. And 3, petitioner is likely to continue to abstain. Okay? Those are the 3 things you've got to prove. What is your burden? Clear and convincing evidence. Who has the burden of going forward with the evidence? You do. Petitioner has clearly demonstrated rehabilitation in the form of acts evidencing personal reform and good character, and recognizes the rules of professional conduct and disciplinary precedent govern their future practice in New Jersey. Okay? That's certainly going to go into your petition, and you're going to have your guy point out the things that he's doing that's going to satisfy this. No misconduct during the period of suspension, including criminal or professional misconduct. Not been convicted or adjudicated or received the benefit of diversionary treatment for criminal or quasi-criminal offenses. Now, I'm going to suspect that will not include, it's going to certainly include DPs and petty DPs. I don't know whether it would include traffic offenses, probably drunk driving, which is a quasi-criminal offense. I'm not sure. That'll have to come up and be developed through the case law. But if your guy had a drunk driving case, you got to address that, okay, during that time period. Certainly, if there's a DP or a petty DP, you've got to figure that out and see whether or not this is going to be a disqualification. All right. Petitioner's been disbarred must have fully paid the required petition fee. That's the $1,500. If disbarred on motion for reciprocal discipline, the petitioner has been readmitted. Okay, so wherever, if you got disbarred because you were disbarred in Pennsylvania, the first step is to get readmitted in Pennsylvania before you start thinking about getting readmitted in New Jersey. All right? Just some black letter law procedures. Petitioner file redacted and unredacted copies of the verified petition with the Attorney Regulatory Board and serve it on the Office of Attorney Ethics. So they're going to be your adversaries in this matter. They'll have a Deputy Ethics Counsel to be your adversary. Petition is the $1,500 that we talked about before. We talked about the filing of the notice to the grievance and all the grievance that have to be put on notice, including those where they got money from the Lawyers Fund for Client Protection. Here is the contents of the petition, and notice that there are 21 pieces of information that have to be in the petition. It's real simple. Number your petition to follow this court rule, okay? 1, 2, 3, 4. It couldn't be any easier. Just follow this as your rubric, okay? This is the way you're going to handle it. 1, 2, 3, 4, 5. All right? Okay. All 20 of them. You guys can figure that yourself. And the docketing by the director, recommendation by the board, is going to work the same way things work now. The board will come up with a decision. They'll make a recommendation to the court, and the recommendation will go to the court, and the court will make a decision as to whether or not you're to be readmitted. They'll probably come up with a rule that will allow you to file a petition for review if you disagree with the board's decision, okay? But the court has the ultimate rule here, okay? And there may be, you may be able to persuade them that the board was wrong. Look, this is a new procedure, and maybe that the board has not done their job properly. They have no precedent to go by. This is entirely new law. So just make your pitch that way. Okay. Now there may be cases where there are factual issues. The board is not going to try factual issues. They will appoint, if there's going to be a factual dispute between your version of what's going on and the Office of Attorney Ethics, they'll appoint, or the Supreme Court will appoint, a special ethics adjudicator to hear the evidence. Usually it's a retired Superior Court Appellate Division judge, and you'll go make your pitch, try the case like you try anything else, and then the special ethics adjudicator will come back with a report, make findings of fact, conclusions of law, and send it over to the board, and those will be the facts that the board will utilize. Same standard that we use now. Again, burden of proof and burden of going forward with the evidence, and the review by the Supreme Court and the Office of Attorney Ethics, all spelled out in the rule. All right, so here's the deal. This should give you all the basic information you need to know to advocate on behalf of somebody who comes to you who's been disbarred, or if you have a colleague, a friend that got disbarred previously and you want to reach out for that person, say, look, there's a pathway back now, maybe I can help you or represent you, or let's get started with this, or you represent a client now who's going to wind up being disbarred. You have a procedure now that you can follow. You know what you have to do, so go do your thing, okay?